On Canberra Live with Marcus Paul. Legal advice from Blumers Lawyers.
Step right up. It's Jennifer joining us this afternoon. Jen Newman from Blumers. Nice to have your company, Jen.
Thank you. Always lovely to be here.
Now, as you might have heard at the start of the program, I have my cranky pants on because I'm so utterly disgusted that a fellow who's been convicted previously for child offences is on the Child Protection Register until the year 2020, but today finds himself again before another magistrate, another court in Goulburn, again allegedly indecently assaulting a 16-year-old child. Now, there's much more to this story, which we will get to later today in Canberra Live. But I just wanted to maybe just get... I know as a lawyer you need to remain very cautious. OK, we've got an update now from Goulburn Jail. So this registered Yass pedophile, his name is Leon Michael Wicks. He's 52 years of age. Goulburn Court has just refused his bail. He'll reappear in court on July 16. Now, that's over another incident which is being dealt with today. In January, the allegations are that in January this year, a 16-year-old boy was allegedly indecently assaulted by a man near Yass. It's alleged the boy was working for the man at the time. Now, we understand through our colleague Ray Hadley in Sydney and broadcast today on 2CC through many callers to his program that this fellow that was actually working for a transport company delivering items to schools. We're not 100% sure this is where the alleged offence, which we won't go into here. But how the hell, Jennifer, you're a lawyer, how the hell does a bloke on a child sex offenders list, a register until 2020, get to deliver anything near a school? Surely it's incumbent upon employers to know of criminal histories of people before they employ them, I would have thought.
Okay, well, I suppose the thing that we...
That's fine.
And it's really important.
This current one, that's fine.
But it is a matter before the courts,
Yep.
and, it's really important to remember that things get said in the public domain and they can change the outcome of a case like this. And as you said, it's such a serious allegation. And if such an allegation is proved to be true, then there are significant consequences for both the victim and the perpetrator when it has been proven. Mm-hmm. And I'm unsurprisingly, a very big believer in letting the court go through its steps.
Oh,
and,
I understand that.
I think something that I was certainly mindful of when I read the news reports that I've seen, I think there was a parole given at some point, that there's some alleged breach of the parole. I'm not sure if that matter's been dealt with. But
no, there are. We understand there are some outstanding matters,
and that's why I'm going to be super careful and probably a little bit boring, and say I'm not going to weigh in on this one. I'm going to sit back and let the very competent courts do their job. It's because we don't know everything. We don't. Well, and it's very dangerous to jump to conclusions. Do you remember we were talking a while ago about mandatory sentencing?
But hang on, yeah. If a bloke's pled guilty to having sex with boys during a Thai holiday, he's pled guilty to this. He's been sentenced to 5 years jail for that offence with a non-parole period of 3 years. He's obviously spent the 3 years. He's been also charged with having child videos.
I do not doubt that the court will take anything relevant that it's produced to it into account when they determine his sentence, if he is found to have committed the offences. But look, I'm just saying, we've had it in the past that there have been media reports that have been a little bit incomplete, that have missed points, and they prejudice trials.
Yep.
And that, I think, is a terrible thing to happen, because no one gets justice.
All right, well, we certainly don't want to prejudice the child, but at the trial... But I think it's important to know that I think it's important for the public to know, and obviously, as does my colleague Ray Hadley, that this bloke who's now appearing before court on more allegations has form, and I cannot for the life of me understand how he's being given a job where he's. And I'll play some audio later of an interview where it's been alleged that his employer actually knew of his past.
Oh, so but there we go again, that cracking word, alleged. We don't know. It might have happened, and if it did, I'm sure that's a terrible thing. But
All
we
right.
don't, and jumping to conclusions is a very dangerous move.
No, understand. Fair enough. All right, okay, let's move on. Then. Now, here's something that we know that certainly has happened over the weekend. And a lower grade rugby union player in the Canberra competition headbutted a ref. And then apparently smacked an opponent.
Oh, this is all a little bit outrageous. I know, I read this and I was quite shocked. But anyway, I did some research on this one. You're going to be excited. I've got
Tell
some
me.
Latin for you.
Yep.
Okay. Valenti non fit injura, which is the Latin phrase that says, to the willing person no injury can be done. So when you're on a sporting field, I'm not much of a sporting girl myself. I'm more about the netball, the non-contact. But
Well, I don't know. I've seen girls play netball. They get a little feisty.
I'm not weighing into the netball discussion. But look, when you've got sports like soccer and AFL and rugby, you've got people going onto a field and they accept a certain level of risk. You accept there's going to be a certain
Except that
amount.
you're going to be headbutted.
Well, and this is no, you don't. And this is what the law says.
Yep.
As long as the contact is within the acceptable rules of the game, then it's probably okay. Even if, if it's really unfortunate, and we do hear these terrible stories of tackles going wrong and people suffering really serious injuries, the law is very clear that those things are just unfortunate accidents. But
So, for instance, the incident that's been highly publicised of the young Newcastle player in the National Rugby League, who is now, unfortunately, by the looks of it, quadriplegic.
oh, it's awful, isn't it?
Yeah. So, in this instance, that would be, as you say, what's that term again?
You want the Latin again?
Yes, the Latin.
Valenti non fit injuria.
So that could well apply there. But
Yeah.
I'd certainly argue that if you're playing football, somebody headbutting you and maybe punching you in the head.
I think a headbutt is probably
part of the
outside
game.
the rules of the
Yes,
game. And look,
yes.
and courts have dealt with ones like this before. There was actually an AFL one in Canberra in the 70s that the
Right.
court ruled on.
Yeah.
A player elbowed another in the face when the ball was nowhere near them, from what I
Okay.
understand of my quick reading. So the court went, that is very clearly outside of the risk that the players accepted when they walked on the field.
All right.
Another one from the 90s, soccer players got into a bit of biff. One broke the other's jaw, one broke the other's ankle, and the court said no, that's taken it too far. So there are lines.
All right. Well, listen, we've got plenty to talk about still. We're with Jennifer Newman in studio from Blumers Lawyers. I want to know about this public servant who claims she received an electric shock through her spine while sitting at her computer using a mouse. Apparently, she has lost her latest compensation case, so maybe we have a chat about that.
On Canberra Live with Marcus Paul, legal advice from Blumers Lawyers.
And the very lovely Jennifer Newman from Blumers Lawyers joining me in the studio today. Now, Jen, let's talk a little about this former public servant who claims she received an electric shock through her spine while sitting at a computer using a mouse. I didn't know that could actually happen.
Well, see, here's the funny thing. So I saw this and I thought, what a peculiar allegation. So I, being the lawyer that I am, I went to the Administrative Appeals Tribunal judgments and I found this decision and I did the lazy Control F to find the word electric. And it only appears twice in the actual judgment.
Right, okay.
And I went and found it, and it says that she was sitting and typing at her computer,
Right.
and she identified a debilitating electric shock through her spine at the time. And I got to thinking about that and the ways people describe pain, and I don't know if it means that she's saying that she felt an electric shock as if she was shocked by something, or that she experienced pain that she described as being like a shock. And, you can think there's, I think there's a standard set of 20 words or something like that people use to describe pain. There's throbbing and piercing and shooting pain, and also like shock-like pain. And I hear a lot of clients with back injuries and nerve pain, things like that, describing it as it's an electric shock.
Okay.
So I'm not entirely sure. Maybe the journalist saw the claim document and it goes into a bit more detail, but from the judgment, I couldn't make much sense of that.
Okay. So she lost the compo case?
Yeah,
So
but it seemed to have nothing to do with the shock, to be honest, on my reading of it.
All right.
Okay, so I had a read of this case, and it seems that the court didn't accept that she was a consistent witness. Her story didn't always perfectly align with some of the other evidence they had. And when a court's got a case before them, a personal injury case like this, they put a lot of weight on the written documents, what was written down at the time as the ball was rolling along. So what did she tell the doctor? What was she telling her employer? And there's some comments in the judgment that she said to her that she wrote one thing down and then she attempted to deny it later.
Okay.
And, you know, there might be more to that. I may not have read it correctly, but it really reinforced to me it is so important if you get injured at work, and even if you don't think it's a big deal, if you think it's just a little thing, just scribble in your diary or put a note on your iPhone. Today, back hurt at work. Sure, it's nothing, but that way, if in a year's time that's just been getting worse and worse and worse, you're able to go and look it up. And those kinds of details... Document everything and don't expect other people to do it for you, because those kind of details can make or break a case.
All right. Now, another story that we want to follow up on is the fact that the ACT Supreme Court's issued a warrant for the arrest of an Olympic boxer who is due to be sentenced for a road rage incident. So we might see how this might affect his sentence. We'll take one more break and come back with Jen Newman from Blumers Lawyers on Canberra Live.
Now back to Canberra Live with Marcus Paul. 1206.
UCC.
And in studio with me at the moment, Jen Newman from Blumers Lawyers. Hello, Jennifer.
Hello.
I've just noticed a great story come through on the Canberra Times. A man who allegedly burgled a Belconnen lolly shop where his sister worked made a series of colourful interjections during a failed attempt at bail today in the ACT Magistrates Court. He described police claims about his drug use as bull... You know what?
Oh, dear.
30-year-old Jeremy William Schwalm immediately apologised as he struggled to keep his pants up while walking into court on Wednesday. Let me read that again. 30-year-old Jeremy William Schwalm immediately apologised as he struggled to keep his pants up. He explained to Chief Magistrate Lorraine Walker that his belt, as well as his shoes and socks, had been taken by the guards.
Well, that is what happens.
Okay, so I guess you'd see a fair bit of this carry on in the courts.
Look, I don't do criminal work, so I'm very rarely in the criminal court. Look, I think the only thing to say on this is when it comes to these matters, let your lawyers speak.
Well, I don't know whether... let's have a look here.
Yeah.
I by the looks of this, he wasn't represented. Now, basically, he made an application for bail, which was opposed by the prosecution. At various points, Schwalm interrupted the evidence of a crime, targeting the team detective who outlined his fears that the defendant would commit further crimes. He was telling the court of Schwalm's suspected use of heroin, ice and cannabis. When Schwalm became animated, he called out, "BS, test me now," even sticking out his arm to the magistrate.
I can understand how it will be pretty tough to sit in a room and have those things said about you.
Yep.
Even so, look, courts are all about etiquette, and it's for a reason. It's because everyone is meant to be the same in the eyes of the court. The court is meant to objectively weigh up the factors before it, apply the law to those factors and come out with an outcome that's in the interests of the community.
Answer me this.
Oh, gosh.
If everybody's equal in the eyes of the law, why do we stand before a magistrate? I'm not being smart, but why?
Well, I think it's because when the magistrate or a judge is on the bench, they're not there as an individual. They're there as a judicial officer. They play a really important role.
Perfect. All right, now quickly let's have a look at this one. ACT Supreme Court's issued a warrant for the arrest of an Olympic boxer who's due to be sentenced for a road rage incident. What's going on there?
Oh, look. Okay, so there's very limited information in the story that I could find, but what it looks like happened, this individual has been arrested and they've been bailed, and one of the standard conditions of bail, I would assume, is something like you've got to turn up to court when your court date comes, and the story would indicate that he didn't.
Right, okay.
And he didn't show up again, and the court said, you know what? There are only so many chances that you get, and sometimes the court will put their foot down, and they've issued an arrest warrant to get this guy back. So,
all right. So, I mean, that's what happens if you don't front to court once or twice. Look, you get a warrant, don't you?
My view of these things, the court is very reasonable, and they're quite understanding of people's circumstances. If there's a reason you can't be there, like if you're sick, you get a medical certificate and you send it to the court, and it's all very polite.
Yeah.
But if you're going to be so disrespectful as to not show, what do you expect?
Jen, it's nice to have you in here. We'll catch up again in a couple of weeks.
I'm sure we will.
Have a great week.
Thank you.
Jen Newman there from Blumers Lawyers, our legal segment every week.